All right, it's talk time now. The House of Representatives is to carry out a detailed public hearing on the activities of the Financial Regulatory Council of Nigeria regarding non-profit organizations. National Assembly correspondent Jokia Disa reports.
In the last 1 week, controversy has trailed the enforcement of the Code of Governance guiding the operations of non-profit organizations such as churches and mosques. In the wake of the controversy, helmsman of the Financial Regulatory Council of Nigeria, Jim Obazi, was booted out of office. The legislators now believe there's the need to take a second look at the regulations in order to avoid conflicts of interest. Minority leader Leo Ogo is the architect of the initiative. He wants the Nigerian authorities to make the Code of Governance clearer to Nigerians since it isn't based on any law passed by the National Assembly.
The powers granted by National Assembly at a particular time, if not properly managed, could create a major problem, and this is what we are saying here. It is important we correct one very, very wrong impression out there in the public, that the National Assembly enacted a law that sets tenure for non-profit organization. I stand to be corrected that there is no enactment of that nature coming from the National Assembly. There is no law that was enacted.
Other lawmakers are in agreement with the minority leader, but want the searchlight beamed on other agencies of government.
Virtually all the parastatals have some kind of delegated legislation embedded in their act, and what we expect is that, having been given the powers, the committee will swing into action and start reviewing the usage of these delegated legislative powers.
You know that service to God is an individual thing between man and God, and I don't believe that National Assembly or indeed any law should now begin to tell a man when to get tired of serving God.
FGRN has been involved in trying to destroy the economy through its regulatory activities. And what they do in FRCN is not more than legislation, which is an infraction of Section 4 of the 1999 Constitution of the Federal Republic of Nigeria.
Part of the regulation causing ripples stipulates that no leader should hand over to family members upon the expiration of a 20-year tenure. Before his unceremonious exit, Obazi disclosed that only 89 out of the 23,216 registered churches in the country complied with the FRCN regulation. Jokia Disa, TVC News, Abuja.
All right, glad to have you join us right now. We have in the studio a lawyer, Uju Okeke, and of course from our Abuja studio, Sam Amadi, also joining us for this topic, another lawyer. So it's a law thing this morning. Let's look at the mandate, really, setting up the Financial Reporting Council. The mandate, the act came in 2011. Do you have any grounds with the mandate of?
Well, I don't have any grounds. I don't have any grounds with the mandate of the FRC. But what I have a grounds with is they overreaching themselves. The FRC is supposed to be a regulation, not a law. The legal framework for the non-profits is the CAMA, and you have the CAC having the oversight function. So now that FRC has come in, what it's supposed to do is to regulate. It's a regulation. But now it shot itself in the leg by overreaching itself, by creating that 20 years tenure and saying that it shouldn't hand over to a family member.
Yeah, but the mandate says they have the right to update. They have the right to decide to an extent. That's what their mandate says. And the CSC and some other regulatory agencies are member of the reporting council. So will you avoid them taking this action without consulting with the CSC, for instance?
My dear, this is an issue of law. If they wanted to do that, they should have gone to the legal framework. They should have gone to amend the CSC, to amend the CAMA, not to on their own change the regulation. A regulation cannot conflict with the law. If there's a conflict between a law and the regulation, the law takes preeminence. That's the law. So what we are saying is, if they wanted to do this, they wanted to achieve this formally, they should have gone to amend the CAMA. If I had amended it in the CAMA, it wouldn't have been a problem. But now that's why there's a lot of hue and cry, because the process is wrong.
Okay. All right, let me bring Sam Amadi here from our Abuja studio. Now, Sam, it's good to have you join us. Now, this controversy going on now, it is not new. They're not just coming up with this. The laws have been there for a little while now. But why the controversy at this time? Can you make us understand?
Well, I think, thank you very much. First, the FRC is created by law, the FRC Act of 2011, number 6. And if you look at that law very well, it grants it power essentially to do a little bit more than the National Accounting Standard Board does, which is basically control the financial integrity of organizations. This new code, the governance code for non-profit, was issued, came into force on October 2016. Now the problem is simple. I think the problem is that perhaps the leadership of that FRC misconceived its power, and then what I call regulatory overreach. They went in to regulate domain that is traditionally, historically private. There are two issues here. One is administrative, one is constitutional. On the administrative side of it, every agency, what we call administrative agencies, have the rights to make regulation pursuant to their enabling enactment. So nothing wrong with FRC making regulations. So I won't say that it contradicts CAMA. But if you look at the principal enactment, the FRC Act of 2011, it's Section 8 and Section 7 that talks about mandate and function. It relates basically more to financial reporting, issues of financial integrity. Little less about succession, political succession, leadership succession, or even governance structure. If you look at the code again, there is a mismatch of arguments about good governance, about object of NGOs, not-for-profit. Essentially, it doesn't even look like a real regulation. It appears to me to be something that kind of, it's too much theoretical. So on administrative law argument, you could say that the regulator exercised the power vaguely, unclearly. And the rule is very simple. Why an agency can make rules that have the force of law, those rules must be strictly within the clear terms.
In the last 1 week, controversy has...
On that ground, you could actually impeach it. But essentially, constitutionally, I think they overreached by regulating the right to association. You can't, anywhere in the world, regulate so impermissibly. There's no public interest, manifest public interest in legislating that any organization, be it Palm Wine Drinkers Club, or be it a club of Juju worshippers, or even any particular, there's no manifest public interest in stipulating the tenure of their founders. It has no manifest public wrong, and therefore no manifest public interest. And so, on the basis of constitutional theory, you could actually struck it as unconstitutional because it went too far to regulate private domain. The rights are guaranteed to secure for us a zone of state non-interference. I have a right as a group of drinkers, a group of golf players, to have somebody be our leader for a life, but they can regulate sales, financial contribution, financial record keeping, because they have impact for public interest. If a church like Redeem, for example, sells book, they have a right to be regulated in terms of sales of good. If they run a school, they have a right to be regulated in terms of managing school. School is a public domain. They're open to everybody, and therefore you have a right to regulate it. They have standard. But if it's about internal management, who is our leader? Who is our spiritual leader? Will be there for life. It's left for the people. So it's totally an unconstitutional invasion of the private domain, contrary to the constitution that guarantees freedom of association and privacy. So people have a right to associate as long as they are not causing any public wrong. And therefore, if there's no manifest public good, there is no need for intervention. Secondly, right. I would say the point about...
Sam, before you go ahead, Sam, before you go ahead, let's go on a break, and then I will come back for you to round off on your point. Yes. Stay with us. Right, if you're just joining us, you're watching TVC Breakfast. We are talking about the Financial Reporting Council issues emanating from their specifications and regulatory governance code. And we have with us in the studio a lawyer, Uju Okeke, joining us in here. And we also have in our Abuja studio another lawyer, Sam Amadi talking about this. Now, Sam, before we went on break, you were giving us some points in there.
Yeah, I said the other issue is the principle of proportionality. Before you intervene as an executive agency, you must be able to diagnose the problem and therefore target your intervention not overbroad, but proportionate to the issue, the problem you want to deal with. In this case, if the problem is lack of transparency in terms of the management of those systems, you can introduce sensible rules that relate to transparency. There was no problem of succession here. And if there is, members of the church have a right under the CAMA and the Article Association to go to court to challenge whatever violation of the individual church interest. So the problem with FCR has, the Financial Reporting Council has great mandate, great job to do. But I think somehow they got carried away, or either lack of incompetence as regarding regulation generally. So the point I want to make is that the code is unconstitutional. The code fails because they acted outside their power. Only the National Assembly has the right to make laws, but they can donate that right to an agency. But the agency must exercise that delegated power strictly in line with the enactment. Otherwise, they would have usurped the right to make laws. Therefore, the code itself is totally went, in my view, beyond the mandate of FRC. And secondly, the most important one is that it has taken upon itself the right to decide to citizens and members of the community how they should organize themselves in private domain. Church, mosque, synagogue, clubs, drinking parlors, these are drinking groups, these are private domain. And therefore, the code guarantees these people the right to decide their own private affairs, except where they now bring themselves off in the public domain. For example, the CBN regulates the banks. They tell you the threshold of deposit, access to deposit or to lending ratio. They tell you the qualifications of members of your board, because you are dealing with the public. It's not voluntary. It's a market. But in terms of voluntary organizations, the state only regulates when there is overriding public interest. And in this case, there is no overriding public interest to say that the general overseer of any church should leave after 20 years. There's no overriding public interest to stipulate in details the functions of secretaries, treasurers, GOs and all that. I think it's totally, either it's incompetence, either it's lack of knowledge, or animus. People are alleging that perhaps there are some grounds to settle, but I don't think so. I think that it's perhaps overexcitement. And so that code is unconstitutional. The Act, the FRC is a great organization. The Act is legal. Should the CEO be sacked, that's a political judgment. But in my view, that law, that code was totally remiss. It's regulatory overreach. It has no public interest, there's no justification. And people are talking about transparency, because people, the political churches have issues. People miss the issue. The issue here is not about how to deal with the wrongs and perceived or real wrongs of these churches. The issue is that we must guarantee for ourselves, and the Constitution does that, a zone of non-interference. And that zone is that we have a right to organize our private, personal, associational life without the overbearing interference of federal agencies. Otherwise, we become an autocracy.
Okay, thank you, Sam. We'll come back to you. Back to Ujuna. You were trying to tell us about the CAMA and the FRC code, this particular one. But from what Sam actually even said, the code came up in 2016, which wasn't part of their original mandate. But there have been some conflicting parts of CAMA and the FRC code. One of them has to do with the number of directors that you're meant to have. CAMA, that's the section 246. Another one has to do with the issue of decision and voting, which is section 236. Can you expatiate on some of this conflicting portion of CAMA and the FRS?
Well, what I'm trying to say about that is that, for instance, if you look at the CAMA, even for any incorporated companies and for incorporated trustees, the CAMA has provided the steps that they would take, even before registration, after registration, as long as the company is running or the incorporated trustee is running, what it should do and what it shouldn't do. For instance, the board of on the board, the CAMA has provided adequately for that. On the issue of who is a trustee, what it takes to become a trustee. In fact, even the life of an incorporated trustee, the CAMA has given the association that came up with it a free hand. For instance, you could decide that we are from an association of lawyers that will be alive for just 10 years. Now, the FRC is saying that if you hold the position for 20 years, or if you have over 70, you have to step down. The question is, must you even be up to 20 years? It mustn't be up to 20 years. So now what we are saying is that on the issue of the board, on the issue of the meeting, for me, looking at the code, sentiments apart, looking at the code as it were, copied and pasted the things that were in the things that are in the CAMA and the ordinary issues of the articles of association of a company, which shouldn't be. For me, the only new issues that the governance code introduced are, number one, the 20 years tenure, and then the whistleblowing part. Those are the only two things introduced, nothing new. And then, now that he came up, and not only that he did not introduce them things that are not new, things that are already in the CAMA, there's a conflict with the CAMA. The CAMA supersedes.
Why?
Because why it supersedes? Because that's the legal framework for incorporated trustees for companies in Nigeria. That's the legal framework. That is the law. The FRC is just a regulation. The FRC usually is in furtherance of the act, and then the FRC will begin to say about maybe where the act is silent, or things that are not very clear in the act. But things that are very clear in the act, the FRC does not have the powers to begin to go into such issues again. For instance, on this issue of devolution of powers, the CAMA, if you look at from section 673 down, that talks about incorporated trustees, and even section 26 that talks about limited by guarantee, because those are the only two ways by which churches or NGOs could be formed. If you look at the provisions of those provisions of CAMA, it has stated, okay, for instance, a group of people, they come up with an objective of a human objective. Oh, we want to do charity, we want to give our money to disabled people. We come up, we form an association. We come up with our own constitution. Remember that before it is registered, the constitution will be sent to, that's for under incorporated trustees, will be sent to CAMA. Then it's under limited by guarantee, is by article. It will be sent to CAMA. CAMA would have looked at, sorry, would have sent to CAC. CAC would have looked at all this. Are you qualified? Look at the members, who are you appointed as members of your as trustees? Are they qualified? Look at your object. Is it legal? Look at all those. So once CSE has looked at it and they deem them legal enough, they issue you with a certificate of incorporation. What certificate of incorporation means is that every act, everything that the law requires to be done has been completed, has been dealt with.
But my question really is, so what's the use of having the CAC, the central bank, as the board of FRC, if at the end of the day, FRC will make laws that are conflicting with these already established organizations and agencies and laws?
Exactly like Sam said, I don't want to say it's a question of ignorance, because I know, I'm sure there will be lawyers there. But whatever it is, whether it was sentiments, whatever it was that happened, they overreached themselves. Sincerely speaking, you want to make a regulation, look at the existing law. What is in the existing law? What does it contain? What exactly are you trying to simplify? Because that's the essence of regulation. What are you trying to simplify? To make it easier for people to understand. That's the regulation. But now you've brought in totally new things that even the CAMA did not envisage, because CAMA has given people free hands on how to go about this one. And now you're trying to...
Can the CAMA be repealed? Can the CAMA be amended?
That is the question. Why not if not? But then that is it. Go and amend the CAMA, not through the FRC. This is like going through the back door. Let me give you an instance. For instance, in section 42 of the Constitution says that every Nigerian, for instance, if you're born in Nigeria, it doesn't matter whether your parents are married or not, you're a Nigerian. Now, another regulation comes in to say that for you to be a proper Nigerian, your parents have to be married for 20 years, they have to live peacefully. It doesn't make sense. Okay. That is overreaching the Constitution. All
right. Let me bring in Sam in here. Now, the Part D of the code talks about accounts and audits of organizations and their assets. We already have agitations from some, especially worship centers, who don't feel comfortable with that part of the code. Now, what is wrong with trying to check or assess or audit the assets and accounts of organizations, or even not-for-profit organizations?
Thank you very much. In other jurisdictions, you make a distinction between various accounts of the organization. I'll give an example. You ought to report sales of goods. So assuming Redeem is publishing, or another church, Trem prints books, sells materials, there's a right to report. There's a right to know how much you sell, because these are commercial transactions by a church. But things like perhaps gifts that people give, tithes and offering, you have to put them under a different bucket. I think the problem with this code and the problem with the way we make law in Nigeria is that we don't do conceptual clarity. First, what are you targeting? If people, we treat sales, we treat profit, we treat every commercial activity different from voluntary gifts that members of a group can give to their group. I have no problem with reporting. It's transparency. So if they ask that you should report every money you make, well, but maybe you should. I mean, for purpose of transparency. But the real problem here is that I don't think that the state should make decisions for churches, mosques, and other associations regarding how they run themselves. Why? Because their mandates do not raise public interest as much. Number one. Number two, clearly, even if the argument about CAMA and the FRC Act, for me, is secondary, because, I mean, even if they amend CAMA, even if the FRC Act was properly, the code properly made portion to that act, it will still be unconstitutional. No National Assembly has a right to make laws that will tell churches how they run themselves, because they're not drawing public resources. And the simple idea of CAMA is that because for them to have legal privileges and prerogatives, they have to be registered. So registration is not a way of annexing them to the public sector. Registration is a way of providing them with some degree of legality so that they can transact as legal persons. It doesn't therefore mean that the church has to be dragged to the point where everything that the people choose to do themselves willingly, they have to be regulated. Take, for example, members of the church. If churches are killing people in their church, then there's overriding public interest to protect rights of people. You step in. If the churches are, for example, sponsoring terrorism, overriding public interest. Section 45 talks about those limitations in pursuit of public order, public interest, public health, and public order. Apart from those manifestly public interests, we have no business talking about how much the church have, how they are governed. So that's a simple problem. It's a conceptual clarity we need. You have no business going to that area. And so my argument for the FRC law and the CAMA is that the FRC Act is an act. If it takes away something from CAMA, it becomes a conflict of law. And of course, FRC as a later in time might have some level of superiority. But for me, the central issue here is those codes acting or posing as subsidiary legislation were incompetently done because they didn't flow from the exact power that the National Assembly gave the FRC. And secondly, which is more important, constitutionally, they violate the right to freedom of association, and therefore they are illegitimate because they allow the state to regulate a domain that the state should not interfere at all.
All right, Sam, thank you very much for coming. This is the much time can permit us right now, but we will be, tomorrow we have to go on with this topic so we can touch all the other sides of this topic to create more enlightenment and awareness. Sam Amadi, thank you very much for joining us from Abuja, and Uju Peace, thank you very much for coming on the program today. We hope to dwell on this topic again tomorrow as we get along. This is where we come to the end of today's edition of the program. I am Mike Okwache.
And I am Busola Mitunwaishe. Bye for now.